So another test for Nigeria's judiciary has ended today with the Supreme Court dismissing an application by Emeka Ihedioha of the People's Democratic Party seeking to remove Hope Uzodinma from office as governor of Imo State. Mr. Ihedioha had applied to the court to order the Electoral Commission INEC to issue a certificate of return to him on the grounds that he was the validly elected governor of Imo State. But in its judgment, the court ruled that the application lacked merit and was frivolous and vexatious, and that given that the 60 days stipulated by law to hear election matters had elapsed, the court lacked the jurisdiction to determine the matter. So another attempt to avenge a political loss falls flat in the Supreme Court, signaling the end of the road for Mr. Ihedioha's ambition to return to Government House in Imo State and delivering an irreversible mandate to Mr. Uzodinma.
Regrets. I have no regrets. I will do this over and over and over again. It is based on the conviction of my spirit. It's based on my scholarship and the research I did. Not out of pride or arrogance, but that this court, being the apex court of the land, is not just a court of law and a court of equity, but it's also a court of policy, to make policy. That a lawyer should not be afraid to bring a case to the court and tell the Supreme Court to reverse itself.
And that's Mike Ozekome, who is a senior advocate of Nigeria and legal counsel to the People's Democratic Party. Well, for more reaction to that Supreme Court verdict, I'm joined now in the studio by barrister Obed Agu, who is a member of Emeka Ihedioha's legal team. Thank you very much indeed for coming in.
Thank you, Charles, for having me, and thank you, Nigerians.
Tell us briefly what happened in court today and your reaction to it.
Well, what happened in court today, it's that the Supreme Court actually had another opportunity to write on the sands of time, but that opportunity was indeed missed out again. I must say first and foremost that the Supreme Court, we all know, serves as the fastener, a binding fastener to the nation. They hear and decide cases that have broad legal and political significance. And once such opportunity avails them, I suppose they would seize such opportunity to write on times of sands. So today in court, what actually happened is something I could call would I use the term, being a minister in the Temple of Justice, I wouldn't want to use a very harsh term on the justices of the Supreme Court, but it's quite unfortunate.
You stop short of using a harsh term.
Yes, it's quite unfortunate.
And I think that rather says it all, really.
Yes, because at the first instance, the justices of the Supreme Court could not even allow the learned silk, Professor Mike Ozekome, to express himself. The matter was not heard. They came out with a mindset. It was written purely all over them that, oh, we are not going to hear this matter. Withdraw this application.
Well, I mean, even the words they used suggested that they were pretty miffed. I mean, they said it was vexatious.
Vexatious. Yeah. It's frivolous.
Frivolous, yeah.
And they dismissed it.
Yeah.
And not just dismissing it, descending on the learned silk with huge sum of cost.
Yeah, they fined you guys, Mike Ozekome, 40 million naira for bringing the matter before the court. I mean, that's a whopping sum. I mean, is he going to pay it, or is there a way around making that payment?
Well, they said he will pay by himself. It's a cost against
Him?
Yes, not even against the his,
God.
his,
Well, I bet you're glad that cost isn't against you.
Well, it is outrageous.
But I mean, look, let's be serious here. Didn't you realize, you plural, being all of
I know,
you,
I understand.
I mean, didn't you realize that the 60 days stipulated by law had elapsed, and as the court said, it lacks jurisdiction to determine the
let
matter?
me put the perspective
Right.
in the right position. This matter, the application that was before the Supreme Court, is not an election petition matter. No.
Right.
It is an application before the Supreme Court to enforce the judgment that was delivered on the 20th of December 2019.
Right, which had to do with Uche Nwosu.
Uche Ugumbanwosu.
Right, who was the governorship candidate of the Action
APC,
Alliance party.
APC and Action Alliance.
Right.
Now, they succinctly put, the Ugumba Uche Nwosu won the APC primaries in 2018 with over 200,000 votes. The present governor of Imo State, Hope Uzodinma, came a distant third in that primaries. So APC submitted the name of Uche Nwosu to INEC. And the law is that when the nomination of a candidate is complete upon submission to INEC. So APC had completed its nomination of Ugumba Uche Nwosu in 2018. Then Ugumba himself went to AA again to get another nomination. And then Action People's Party, I represented at the Federal High Court in 2019, went to court and said, no, that this amounts to double nomination.
And that sounds like it.
Yes, this is double nomination.
Yeah.
And the judge of a Federal High Court, Epo J, found in our favor, yes, that this is double nomination, and disqualified Ugumba Uche Nwosu on that basis of double nomination. Now, which ordinarily means that APC, having not completed nomination of Ugumba Uche Nwosu, does not have a candidate for that election. And AA as well does not have a candidate for that election because Uche Nwosu is double.
Was straddling the two parties.
Yes.
Right.
So it's a double nomination and it's against the tenets of the law, section 37 of the Electoral Act 2010 as amended 2015. So move fast forward to the Court of Appeal, still held the same position. In 20 December 2019, the Supreme Court agreed with the concurrent decision of the both courts, of the lower courts, saying that, yeah, they agreed that the nomination of Uche Nwosu is a double nomination, and thereby Uche Nwosu cannot be a candidate in the election.
Yeah, but doesn't that disqualify Uche Nwosu rather than disqualifying the party itself and all the other candidates?
No, what it did was to disqualify Uche Nwosu as a candidate of APC, which ordinarily means APC does not have any candidates going forward. Because before the judgment, APC has submitted the name of Uche Nwosu to INEC, which means it is concluded. Nomination was concluded as at that time.
Yeah, but if a court disqualifies a candidate, does that prevent the APC from submitting another name?
The only thing that APC would have done was if Uche Nwosu had withdrawn his candidacy,
right,
or according to the law had died. But Uche Nwosu is still alive.
Yeah, but he was disqualified.
And never withdrew his candidacy.
Yeah, but withdrawing his candidacy becomes irrelevant if he's been disqualified by a court.
If he's disqualified, yes, that means APC does not have a candidate. How would they have had a candidate when at the time he was disqualified, nomination had closed?
He was the only name that they managed to submit before the nomination closed.
No, before close of nomination.
Yeah, that's what I'm saying.
So as at the time they submitted his name and nomination closed, there was no opening for further nominations. So how dare come a Hope Uzodinma on the ballot? That is the first question to be asked.
But the court didn't give you guys a chance to
do all this, to explain all this.
And you were not, in fact, asking for the Supreme Court to review the subsisting judgment of the court delivered in the appeal of 2019, nor of the one delivered in January 2020, which favored Hope Uzodinma and sacked Mr. Ihedioha from office.
Not at all.
Right.
That was not the application that was before the justices of the Supreme Court. The application that was before the justices of the Supreme Court was
purely the Uche Nwosu
affair. That you have given a judgment in favor or against Uche Nwosu, Ugumba Uche Nwosu.
And Emeka Ihedioha,
can you put effect to that judgment?
And Emeka Ihedioha then joined as an interested party in the matter. Right.
So because he is ordinarily, assuming but not considering that nomination had not closed as at the time Ugumba was disqualified, could it have been Hope Uzodinma that would have taken the position? No, because he came third.
So what do you think happened there?
I wouldn't know. That's the question that is left for INEC to answer.
No, I mean what happened with the Supreme Court? Because Hope Uzodinma now has what appears to be an irreversible mandate. Is that right, or is there any more legal maneuvers that you have up your sleeves on behalf of Emeka Ihedioha?
No, ordinarily they say the Supreme Court is the final court of the land.
Yeah, but obviously they had said that they had sacked Emeka Ihedioha, and you came through another route. So I'm wondering if there's another route that you've got in mind.
It is not another route. Sorry, what happened is not coming through another route. What happened is that we looked at the matters. We saw that this judgment is
it's a different route from the appeals that were made against him, or that he appealed against and got sacked.
The appeal of January, the decision of the Supreme Court of January was on the general election.
Right.
You understand? And this was on the pre-election issue that came before the Supreme Court.
But they said it's a pre-election matter, basically, and that they can't decide.
They said it's a pre-election matter, but time does not count.
It's not time-bound.
It's not time-bound because it is an illegal action.
So what are you going to do now? As a legal team, is that it? Your options are over?
Well, the Supreme Court is the apex court of the country, and that is the final court of justice.
Right. No, I understand that in this particular Uche Nwosu instance, but is there any other thing
that
there
is nothing because the Supreme Court today has said they didn't even hear us.
Well, in that case, I think you deserve a drink, and I'll let you go and get one. I want to thank you very much indeed, Barrister Obed Agu. He is a member of Emeka Ihedioha's legal team and a very articulate man at that. Thank you very much indeed.
Thank you, Charles.